matter to come before the court this morning is Lamar versus the State of Ohio. We stood up 1 minute, so.
Mr. Whitney waived. Yes.
Okay.
Yeah, somebody hold us.
Okay. That being the case, Attorney Bremer, you'll have 50 minutes in which to present your case.
Okay.
We have ready to brief, so we're ready to proceed when you are, sir.
Thank you, Your Honor. So Brian Bremer on behalf of the City of Akron. Some of you will remember it. This is exactly what I was asking about, where I'm the appellee in this matter and the appellant is not here. So it puts me in a little bit of an awkward position to be, because I don't feel like there's any error in this case, obviously, and so it's a little bit more, I'll try to keep my remarks brief and to the point. This matter is before you on a challenge to the sufficiency of the evidence brought by the counsel at trial by way of the Criminal Rule 29 motion. As you are well aware, the Criminal Rule 29 motion should only be granted where if you view the evidence in the light most favorable to the prosecution, reasonable minds could only conclude that there was not sufficient evidence to convict someone. In this matter, viewing the evidence from the trial in the light most favorable to the city, very clearly there was sufficient evidence to find Mr. Moss engaged in obstruction of official business. It's unclear to me from reviewing the brief exactly what Mr. Moss's argument is about the evidence. I do think that what he's saying is that the officers did not have any reason to be questioning him on the night in question.
If he's arguing that he no longer had reasonable suspicion of a crime once he approached and didn't see sexual activity, looked in the window and saw him. And then I believe Mr. Moss said they were doing nothing wrong. But I think you're right, that's his argument.
And I think, and with that in mind, what the officers saw was they were on patrol and they happened to observe a vehicle in a parking lot of a closed down bar. It was about 3:50 in the morning, 4 o'clock, and the officer who testified, Officer Sherrick, said that he knew that parking lot had a reputation for drug activity, solicitation, other kinds of illegal activity, and he actually made arrests in that parking lot himself. And so when he saw the car sitting there by itself, he thought that seemed odd, and he decided he was going to go investigate that further. And as they approached more closely, they observed an individual in the driver's seat, who was Mr. Moss, reclining backwards. There was a woman in a passenger seat who was leaning over, and the officers thought that they were engaged in sexual activity. They got further, they approached more closely. They apparently were spotted by the individuals inside the vehicle, who then engaged in further movements, according to the officers. But Officer Sherrick testified at the trial very specifically that the furtive movements were not the typical furtive movements you hear about in cases. He did not describe it as them trying to hide drug paraphernalia. He did not describe it as trying to hide a firearm. What he described it as, it seemed like they were trying to straighten their clothing back into a position that basically was covering up the activity they were just engaged in. And so when everything he saw leading up to actually approaching the vehicle indicated that sexual activity had been occurring in that vehicle at the time when he observed them, which would be in at least a reasonable suspicion that a crime had occurred, which at that point he has the right to actually investigate further and try to discern whether or not his suspicion was correct or if he didn't have enough evidence to go forward. And there seems to be this idea that just because he happened, if you get to some place that you think a crime has occurred and the evidence has been hidden, you have no right to ask questions. And that's not true. The officer absolutely had the right to engage further on this. And because he has reasonable suspicion, Mr. Moss was actually obligated to provide him with his personal information as part of the investigation process. That's required by the Ohio Revised Code. Mr. Moss refused to do that. Mr. Moss refused to obey commands to keep his hands where the officers could see them. He basically consistently moved his hands around his waist, otherwise moved them out of places where the officers could see his hands, which caused some great concern with the officers. and generally disrupted the actual attempt to get information about the act that they've been concerned about. Then Mr. Moss went further, and he even said, "I have the right to be here. The bar owner told me I could be here." And the officer said, "Well, we'll call the bar owner, we'll confirm." And Mr. Moss said, "No, I'm not going to give you my name to tell you so you can do that." And so Mr. Moss is going beyond just refusing to actually identify himself. He's starting to go down, like, give the officers misleading information, quite frankly, because if that was true, there's no reason why he wouldn't have them. We'll call the bar owner. And then it goes even further that when they asked his passenger what her name is, Mr. Moss started interrupting the officers. He started being loud, belligerent, and generally trying to prevent her from giving her name to the officers. Even assuming Mr. Moss had the right not to give his name, which isn't true, like he actually had to, even assuming that he did not have the obligation to give out his name, what he did when the officers were trying to inquire into the woman's personal identifying information was obstructing of official business. That in of itself would have been good enough, but because it went beyond just mere protest, he actively tried to prevent her from answering questions. And that's on top of the fact that he engaged in his own refusal to answer questions. He also consistently ignored commands from the officers and generally made the situation far more dangerous than it needed to be at that time of night in that location. And Mr. Moss quite simply brought the charge upon himself, because the officer said that if he just answered the question, he probably would have, the entire stop would have been 5 minutes, and the stop ended up taking 40 minutes for the officers just to identify the passenger and Mr. Moss, which was all part of their actual investigation they were allowed to be conducting. And with that in mind, that was good enough to rise the level of overt act interfering with an authorized police investigation. So, Mr. Moss, there's very clear sufficient evidence under these circumstances to conclude that Mr. Moss had obstructed. And again, this is viewed in the light most favorable to the prosecution. And with that in mind, the city would respectfully request that this court overrule Mr. Moss's assignment of error and affirm the decision of the acting municipal court. I'm happy to answer any questions.
Is there a difference between the officer having an idea that sexual activity was occurring, or, for want of a better word, a hunch that there was activity occurring versus?
This would go beyond being a hunch. The officer knew that the parking lot had a reputation for being a solicitation area. He knew that the bar was closed. They weren't patrons of the bar, the business that they were behind. He also saw activity, like the positioning of the bodies inside the car led him to believe that sexual activity was occurring. And then when he approached, they engaged in an activity which was trying to rearrange their clothing to cover themselves back up again. So basically, it wasn't just a hunch. The officer saw a lot of different things leading up to the moment he actually encountered and talked to the individuals inside the car about what the activity was. And under the Ohio Revised Code, reasonable suspicion is good enough to get to the point of you having to provide your information. And beyond that, it's important to keep in mind that reasonable suspicion is less than probable cause, which itself is less than even a preponderance of the evidence standard. It's not, and that's probably why he never even got charged with anything, because frankly the officers, even after interviewing him, didn't have enough to bring him on any of the solicitation or anything like that. There's no, they did not have enough evidence to actually get to that point. But they definitely had enough evidence to investigate further and see if they could uncover additional evidence that inside the car that would have let them come to the conclusion that the activity they thought happened actually had happened.
So you've got some time here. Let's assume that he did not say anything to the female passenger, just told the police officer that I'm not giving you my name, my date of birth, my address. Is that obstructing?
Well, with the typical caveat of that isn't our facts, the officer, I would say that is a closer call, because in this circumstance he did engage in additional, he also was engaging in furtive movements during the entire investigation, which was distracting to the officers because he ignored their commands consistently to keep his hands where they could see them, which led to this inherently taking longer than even refusal to give the information would have. because they had to try to make sure that he wasn't armed, he wasn't producing a firearm. They had to concentrate on that instead of on just his actual response. And that itself would have been a separate crime if he had refused to provide the information. I don't know if you were just to look at just the refusal to give information, if that would be considered obstructing official business. But again, that's not the facts right here. There's more going on here than just the outright refusal to give his personal information.
Thank you, Attorney Berman. We'll take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted to our website and then.
Thank you, Your Honor.
Thank you.